Well, hey there, folks. Bill O'Leary. And what I want to do is I want to go live and I want to talk about the topic, which is 3 ways to protect your estate from probate delays. So, for those of you coming across this for the first time, this is what we call our Thirsty Thursday series, where I go live once a week, Thursdays, usually late in the afternoon, to talk about a different topic that I come across or I see or I've talked to somebody about in my 9 to 5 job, which is as an estate planning attorney with Legacy Planning Law Group here in Jacksonville, Florida. So, 3 ways to protect your estate from the probate delays. Let's jump in. If you're thirsting for knowledge, then you've come to the right place, I'd like to think. So probate, what is it? So it's a legal process. It's the legal way of sorting out a person's estate after they die. And going through probate can take a lot of time and get pretty complicated. Delays in probate can tie up assets for months and sometimes in excess of a year, even multiple years. And what this does is it causes stress for beneficiaries. It's also very, very expensive because the attorney under our law in Florida is entitled to a percentage-based fee based on the value of your assets when you pass away, between 3 and 5%. Well, fortunately, there are some approaches, strategies to protect your estate from these delays, which would ensure that your family or loved ones can access their inheritances more swiftly and with less hassle. So, let's talk about the 3 ways. Number 1, first and foremost, put in place what's called a revocable trust, also known as a living trust. One of the most effective ways to bypass the probate process altogether is by setting up a revocable living trust. This tool, you see, this trust allows you to transfer ownership of your assets into the trust, and the trust itself is managed by a trustee. That's typically you while you're living. And what you do is you name beneficiaries to receive the assets in the trust after you pass away, all without having to go through probate. And so what happens is the assets in the trust, as I said, go directly to the beneficiary that you name, again, without any intervention by a judge. So sort of the benefits of a living trust or a revocable trust is it avoids probate. And it gives the flexibility during your lifetime that you so covet, because it can be changed, it can be altered, it could be revoked, in fact, canceled, or something short of that. It could be changed, it could be tweaked as your life circumstances change. So consider this. It's important to ensure that as you put a trust together, all of your important assets are appropriately titled in the name of your trust, at least those assets that are appropriate to put into a trust. Because understand, if you have an asset that was not put in the trust when it should have been put in the trust and doesn't otherwise, let's say, have a beneficiary named on it, then that asset is going to have to go through the probate process, and that kind of defeats the purpose of doing a trust. So creating a revocable living trust, bottom line, provides very clear, a very efficient pathway forward for asset distribution at your death, minimizing the potential for probate delays. Okay? So way number 2, the second way to protect your estate from probate delays, designating beneficiaries on certain accounts, retirement accounts, life insurance, that sort of thing. And so what you can do with these types of financial assets, you can designate beneficiaries directly, and these designations will usually override what's written in a will, meaning the assets can be transferred to the named beneficiaries immediately upon death, bypassing the probate process. So, an obvious benefit of having a beneficiary designation on this type of financial account, it's straightforward to set up, and it can ensure that the assets are transferred quickly, smoothly, and easily. Something to consider. Regularly review and update your beneficiary designations to reflect your current wishes, because your wishes will change over time, especially after significant life events have happened, like the marriage. You may get married, or maybe, let's say, the birth of a child, death in the family, that sort of thing. So take advantage of direct beneficiary designations, because what they can do is they can protect significant portions of your estate from becoming sort of caught up or ensnared in the probate process. And then way number 3, the third way, joint ownership with right of survivorship. Holding property jointly with a right of survivorship is another approach to avoid probate. This arrangement means that upon the death of one owner, the property will automatically pass to the surviving joint owner without the need for probate. So an obvious benefit of having joint with survivorship is that it ensures a smooth and sort of quick transition and transfer of those assets to the other joint owner. Now, understand this. While having joint ownership can certainly simplify the transfer of assets, it's really, really important to think about the implications of adding someone as a joint owner, because they're going to have equal control over the asset during your lifetime. Plus, you might be exposing yourself to the other joint owner's liability. Think they get into a car accident, and now that injured driver can force a sort of a breakup of that joint asset, that joint account, let's say, or even that joint property. So joint with right of survivorship, yes, it offers a simple mechanism for avoiding probate on crucial assets, preventing those probate delays, but it does come with some risks. Talk with your estate lawyer. So sort of the bottom line is probate delays, they can be a substantial source of sort of frustration and hardship for your heirs. And what you can do is you can safeguard your estate from these delays by implementing strategies, if you will, like establishing a revocable living trust, which in my view is by far the best way to do it. But you might also consider designated beneficiaries on accounts and opting for joint ownership with right of survivorship. So just understand that proactive estate planning allows you to provide for your loved ones with really kind of minimal obstacles that you would impose on them, offering both you and them, frankly, peace of mind. So do consult with a good estate planning professional to make sure your estate is set up in a legally sound way, in a comprehensive way, and that's aligned with your wishes. So if you'd like to know just a little bit more about the ways to protect your estate from probate delays, and maybe if you want to know, hey, can we help you here at Legacy Planning Law Group, we would love to talk to you. So we invite you to start the process, start the conversation, take that initial baby step by scheduling a free 15-minute phone call. Just go to our website, Legacy Planning Law Group, click on the button, you can't miss it, on the homepage and other interior pages, book your free call. It'll take you straight to our booking calendar, pick the day and time that works for you. By the way, that call, that discovery call as we call it, is complimentary. If you've enjoyed this video, like it, share it as well, and click on the notification bell as well. Hey, if you have not already subscribed to our YouTube channel, go ahead and do that, would you? Legacy Planning Law Group. We're so gratified with the subscribers that we have. So, hope you've enjoyed this talk about the 3 best ways to avoid probate delays. I'm going to give another talk next week, Thursday, God willing. Part of our Thirsty Thursday series. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, I'm going to go ahead and sign off for now, and go make it a great day. And if you can, even in a small way, make it a better world.